Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Oh my goodness, what a week. If you know, you know. Here's some stuff you might not know. In Texas v. Mayorkas, District Court Judge Kazmarek appears to believe that Texas has standing to challenge immigration stuff based on a theory that immigration changes anywhere affect Texas. Not only that, the D.C. Circuit all but shut down lawsuits brought to preserve and set aside diversity visas for those people harmed by the Trump era and COVID, slowdown in processing diversity visas. I believe it will now make thousands of less such visas available. Then in Ravi v. United States, the appeals court reversed the district court's dismissal of a class action lawsuit brought to recoup funds paid to ICE in their phony Farmington University scheme. So we're all over the place this week, and that's just the beginning. Also this week, on June 26 specifically, The Guardian reported that former Honduran President Juan Orlando Hernandez was sentenced to 45 years in prison for, essentially, letting his military help drug smuggling into America. Former President Hernandez, who only left office in 2022, swears that he is innocent and apparently testified in U.S. federal court under oath that, quote, drug money was paid to virtually all political parties in Honduras, end quote. I don't know, seems kind of important for a Convention Against Torture case to me. Link in the show notes. And if all of that wasn't enough, this week DHS extended and redesignated temporary protected status for Haiti, which should mean that previously ineligible Haitian citizens, who are now in the United States, are eligible for TPS. 309,000 to be specific, according to DHS. And all of that is before we even get to Chevron deference. See you in a sec. Our first case is Loper Bright Enterprises v. Raimondo, published by the U.S. Supreme Court on June 28, 2024. What a time to be alive. When I read about the 60s and other cultural revolutions as a kid, I didn't really feel the need to be living through one, and certainly not one spearheaded by a judiciary and the Federalist Society. But that is the world we find ourselves in today. And my goodness, to echo the complaints of the much more respectable case law podcasts like Amicus and Strict Scrutiny, need the revolution continuously occur on Fridays in the summer? Like there's no better time. This case is about federal court deference to administrative agencies. It's about power. The BIA, USCIS, Department of Labor, and the Department of State are all administrative agencies, so yeah, this case affects immigration. Although not so much the Department of State, after the Munoz decision from last week. I'm not going to get into the saga of these fishermen who don't want to pay for government passengers that is at issue in this specific case. or do a deep dive into what a change of law of this magnitude really deserves. Other podcasts will do that for the next month, and Ira's going to come on to talk about this and some other Supreme Court cases soon. I will say right off the bat, though, that while many in the immigration bar are cheering on the death of agency deference, it seems to me generally bad for many things, including climate change, and that the effect on deference in the immigration context is far from clear. Chevron is dead, and so truly I'm not sure what the heck the BIA plans to do going forward, where literally none of their precedential decisions are entitled to any deference anymore. But also, none of this affects circuit decisions that rested on the plain text of the INA. While this will surely lead to favorable results in some circuits, other circuits, such as the 11th Circuit, have already issued decisions over the last few months, discussed on the pod, that seem to be laying the groundwork for special deference in the immigration context. Far then from being the end of agency cases before the Supreme Court, this is only the beginning and likely the floodgates. I'm sure an immigration case will make its way up to the court in the next few years and begin clarifying things for immigration attorneys. Anyway, so there are my thoughts even before doing the case. Here's an abbreviated Loper Bright summary with a mind towards immigration. The Chief Justice authored the decision with Justices Thomas and Gorsuch writing separate concurrences, and Justice Kagan and Sotomayor in dissent. No Justice Jackson, because the Supreme Court decided to take this monumental question in a case that Justice Jackson decided to recuse herself from based on her involvement in the matter below. In 1984, the Supreme Court issued Chevron USA Incorporated v. Natural Resources Defense Council Incorporated. In that decision, the court held essentially that federal courts should defer to agency interpretations of ambiguous statutes where the statute at issue governs the agency's work, the interpretation is reasonable, and of course the statute is truly ambiguous about what to do. So like if Congress passes a statute that makes it a violation for companies to leak a burdensome amount of greenhouse gases into the atmosphere, the EPA would likely be the administrative agency that could interpret that clearly ambiguous statute to decide what burdensome means, what greenhouse gas means, etc. If the EPA then applied that interpretation to fine a corporation for leaking 1 million tons of CO2 into the atmosphere, and the corporation sued, Chevron deference would have required that the government win the lawsuit so long as the federal court believed that the statute was ambiguous and that the EPA's interpretation of the terms that it was applying was reasonable. Or say here, where essentially a federal fishing agency interpreted its statutory mandate by requiring local fishermen to pay for the federal observers that were required at times to be on their own boats to make sure overfishing didn't occur. Bad facts do sometimes make bad law, no doubt about it. Anyway, no longer. Chevron was wrong from the start, explains the majority. The Chief Justice explains that the framers envisioned that Article III courts, federal courts, would be the final arbitrators of disputes and interpreting congressional statutes. Nothing particularly remarkable about that, but also early on, explained the Chief Justice, the Supreme Court, quote, also recognized that exercising independent judgment often included according due respect to executive branch interpretations of federal statutes, end quote. But respect doesn't mean being bound. Again, not very controversial or remarkable of an observation. Justice Roberts then turns to President Roosevelt's New Deal and how it expanded the administrative state, like, for example, enabling the federal government to cut back on child labor and providing electric power to Appalachia. Supreme Court case law on agency law from that time started to develop, Skidmore deference in 1944, for anyone who took administrative law. Many pages in this decision on that history. Then Congress enacted the APA in 1946, arguably the most powerful tool of immigration litigators, but the law did not require deference to administrative agencies. Quite the contrary, actually, explained the Chief. The Administrative Procedures Act provides a way for litigants to sue administrative agencies in federal court. Then came Chevron, putting a thumb on the scale for agency interpretation in 1984. And that is true, provided again that the statute is indeed ambiguous. The Chief and the majority believe Chevron was wrongly decided. A decision that, if I'm not mistaken, has become the most cited and relied upon or distinguished Supreme Court decision in history, given how many administrative law cases there are, and how many are now going to flood the federal courts. Chevron defies the APA and the U.S. Constitution, explains the majority. It is the federal courts that have power in America, something that Senator McConnell has long recognized. And, quote, in fretting over the prospect of allowing a judicial interpretation of a statute to override an agency's, Chevron turns the statutory scheme for judicial review of agency action upside down, end quote. If you want to read all the justifications for keeping Chevron deference, read the dissent, and the hundreds of decisions over the last 40 years, explaining why we have it. But regardless of all that, this is what has now happened. The Supreme Court just gave the federal judiciary immense power over nearly every aspect of American life because modern states like America are operated by a wide range of administrative agencies. And now the federal judiciary has the final say, without the administrative agencies, comprised of experts in the field, really having much of a say when it comes to federal court lawsuits. True, quote, in an agency case in particular, the court will go about its task with the agency's body of experience and informed judgment, among other information at its disposal, end quote. But it's the federal courts that have the final say without any deference to the administrative agency's expertise on the subject. Plus, the Chief Justice and the majority believe that applying Chevron is already chaotic, so might as well get rid of it. So in the immigration context, for example, that means no deference to precedential BIA decisions interpreting the INA or other areas of immigration law. If, as has appeared to be the case over the last couple of decades, the BIA has generally been less favorable to non-citizen arguments, this would seem at first blush to be a decent thing for non-citizens. But in a quote that I don't love for future immigration litigation, quote, that is not to say that Congress cannot or does not confer discretionary authority on agencies. Congress may do so subject to constitutional limits, and it often has, end quote. I don't want to be negative and say that this isn't going to be great for immigration, but really we are just at the beginning. The Chief concludes, quote, Chevron is overruled. Courts must exercise their independent judgment in deciding whether an agency has acted within its statutory authority as the APA requires. Careful attention to the judgment of the executive branch may help inform that inquiry, and when a particular statute delegates authority to an agency consistent with constitutional limits, courts must respect the delegation, while ensuring that the agency acts within it. But courts need not, and under the APA may not, defer to an agency interpretation of the law simply because a statute is ambiguous, end quote. So ordered. My goodness. What does it all mean? I kind of hit it during the case, but I'll discuss it a bit again. As to immigration specifically, that phrase, that word, barely appears anywhere in the majority, concurrent, or dissent. There are hundreds, if not thousands, of precedential circuit decisions deferring to the BIA's interpretation of ambiguous INA provisions under Chevron, not to mention the regulation decisions that are really better governed by Kaiser v. Wilkie. Are all of those immediately bad law, or rather simply subject to a renewed challenge? I think the latter. Although will some circuits say that the rule that panels can't override other panels require en banc rehearing of every such case? I doubt it, because Loper is so fundamental, but who knows? The Supreme Court itself says that its prior holdings that had relied on Chevron are still subject to stare decisis, even if Chevron isn't itself. So might the circuits take a similar approach to immigration case law? We will see. It does seem, however, that the role of the BIA in particular has just been devastated and become much less appealing to an intellectual. The BIA is still absolutely reviewing the decisions of immigration judges, but the BIA's interpretations of what the many ambiguous INA statutes mean have now essentially become advisory opinions to the circuits. So too with the AAO and district court challenges, if you can even get review after Patel and the like. Whether that's ultimately good or bad for non-citizens remains to be seen, and likely will come to depend a bit on geography. And I'll tell you what, if anyone was worried that this podcast wouldn't have enough cases to review in the future, well, you couldn't have been more mistaken. Nor should this decision really come as a surprise. In at least the cases of Justices Gorsuch and Kavanaugh, they were overtly telegraphing that this was their view of agency law well before they were even appointed. When potential Supreme Court justices tell us through their writing what they believe, we should believe them, and not so much what they say about stare decisis in their Senate confirmation hearings. Finally, I could not help but compare recent Supreme Court decisions with this one, if only to display where the court's head is at. A reasonable reading of this majority decision would indicate that the court sees it as egregiously wrong for the Supreme Court to have crafted a judicial framework that put a slight thumb on the scale of the executive when it came to litigation. But in other contexts, a majority of the court seems unbothered not only by thumbs, but by entire hands. For example, qualified immunity is a judicially created concept that so heavily weighs in favor of the executive that it is exceptionally difficult to sue state police or other state actors for alleged wrongdoing. And in the immigration context, look again no further than Munoz last week, where the Supreme Court not only had no problem with the doctrine of consular non-reviewability, something that it itself made up, but extended it and made it almost, if not entirely, ironclad. No lawsuit against the executive agency for agency action at all when it comes to these consular decisions, it seems. Like I mentioned, I'll have Ira on the pod to talk more about this case and some others soon. But these are some thoughts that immediately came to mind for me. Us lawyers truly are entering a whole new world if we weren't there already. And that is Loper Bright Enterprises v. Raimondo. Okay. Turning to Santiago Lopez v. Garland, published by the 7th Circuit on June 24th, 2024. This case is about non-LPR cancellation of removal. Mr. Santiago Lopez is from Mexico and has lived in the United States for quite a while. He got 3 DUIs, the last in 2012, which initiated removal proceedings. He's been working at a pork company in Wisconsin for decades and supports his wife, who herself cares for their 4 young U.S. citizen children. Unsure if his wife has status, but everyone seems to agree that without him, she'd have a rough go of it supporting 4 children in the United States, and that similarly, relocation to Oaxaca would create a significant hardship. Against this, as a matter of discretion, are at least the 3 DUIs. Although Mr. Santiago Lopez and his wife testified in 2018 that he hadn't had a drop of alcohol since the last DUI in 2012. The IJ denied relief. The IJ assumed that Mr. Santiago Lopez had satisfied the non-LPR cancellation of removal standard, including the high hardship standard, but that he didn't warrant the relief as a matter of discretion because of the DUIs. The IJ weighed the positive and negative factors as explained in the BIA's 1976 decision Matter of Marin, but really it came down to the DUIs and the fact that Mr. Santiago Lopez never sought treatment. Although, does it really matter if he went cold turkey? I don't know. The BIA affirmed, presumably applying de novo review, on the issue of discretion. And the 7th Circuit held that, well, it couldn't review it at all. Yes, there's the Supreme Court's recent Wilkinson decision that likely would have permitted circuit review of a hardship denial if that had happened here, but that is not what happened. The IJ and the BIA denied purely as a matter of discretion. Under Patel, such a challenge is pretty much dead in the water at the circuit level, and to the 7th Circuit, Wilkinson didn't change that. In fact, it made it more clear. In Wilkinson this term, the Supreme Court held that a, quote, discretionary determination on whether or not to grant cancellation of removal in a particular case is not reviewable as a question of law, end quote. Now, the 7th Circuit did issue some favorable logic here. The 7th Circuit held that even if the IJ and the BIA deny solely on the issue of discretion, if Mr. Santiago Lopez or another non-citizen was arguing that the IJ and the BIA made procedural errors when conducting the discretionary analysis, that could be reviewed. Like, say, quote, altogether ignoring evidence bearing on his family circumstances, end quote, or mischaracterizing evidence. That would be a question of law in the 7th Circuit that survives Patel and Wilkinson, notwithstanding the fact that it's ultimately tethered to a discretionary decision. Rock on with that. But it appears that the record is not clear exactly what Mr. Santiago Lopez was arguing here, likely because Wilkinson came out while the case was pending, and in any event the Seventh Circuit sees the challenge as more about how the IJ weighed evidence during the discretionary analysis, and not whether the IJ mischaracterized or ignored evidence. And that, to the Seventh Circuit and likely all other circuits, can no longer be reviewed. Seems like the notice to appear was also deficient, and the Seventh Circuit has some favorable case law on that, in regard to dismissing proceedings outright. But it wasn't favorable enough for Mr. Santiago Lopez. Claims processing rules must still be asserted timely, and here, Mr. Santiago Lopez didn't raise the deficient NTA stuff until his appeal to the BIA. Likely because of the change of law, but still not timely enough to the court. For all of these reasons, Mr. Santiago Lopez lost his case. And that is Santiago Lopez v. Garland. Moving on and eventually concluding with 3 decisions out of the Ninth Circuit. The first one is Manzano v. Garland, published by the Ninth on June 25, 2024. This case is about asylum. It's authored by District Court Judge William Orrick, sitting by designation, who also presented at the Federal Bar Association's Immigration Conference in Salt Lake City earlier this year. Before becoming a federal judge, Judge Orrick was the Deputy Attorney General or Assistant Deputy Attorney General in charge of oil, so he knows a bit about immigration. Mr. Alfaro Manzano is from El Salvador and first came to the United States in 2003. During that time, he became a Jehovah's Witness and was baptized in 2008. Everyone seems to agree that he's devout and that he finds purpose in this religion, including the preaching which he, quote, must do, end quote, as a Jehovah's Witness. He returned to El Salvador on his own, it seems, in 2011, and joined the Jehovah's Witnesses there, preaching in the streets, which included telling young people not to join the gangs that have significant power in El Salvador. The gangs didn't like that. Members hit him, called him names, kicked him, and, quote, told me to go to shit, that I was a testicle of Jehovah, end quote. I hope for the gang's sake that hits better in the original Spanish, because really, that is a pretty dumb insult. Things got more serious in April 2012 when the 18th Street Gang members told him in so many words that they'd kill him if he didn't stop preaching. They also demanded payment, as they so often do. He refused, and within weeks they returned and showed him the gun that they had, making known that he'd pay the consequences. A few weeks later, men tried to run Mr. Alfaro Manzano off the highway while he was with his wife. They were gang members. Mr. Alfaro Manzano and his wife fled to another part of El Salvador to live with his mother, and he started preaching again, but the gang started calling his mother, demanding money and threatening to kill the family if he didn't pay. So Mr. Alfaro Manzano fled to the United States in June 2012, and his mother then stopped receiving the calls. An expert testified at the asylum hearing in immigration court and explained how all this made sense based on how El Salvador works, at least in 2012, I suppose. Jehovah's Witnesses, for example, are easy to spot. Not just because of what they're preaching, but because of how they dress. Mr. Alfaro Manzano, for example, wore a business suit and a tie when he preached. And oh boy, I've never actually seen one of these on petition for review. The IJ granted withholding of removal, but not asylum, because of the fact that in the Ninth Circuit, like the Sixth Circuit, the withholding of removal nexus standard is lower than asylum. The IJ determined that religion would be a reason, but not one central reason, for the harm that the IJ believed Mr. Alfaro Manzano would more likely than not suffer, and which presumably the IJ believed the Salvadoran government was unable or unwilling to protect Mr. Alfaro Manzano from. Just an aside, because of the Loper Bright decision that we just talked about, I'm nearly positive that the BIA's matter of CTL on nexus is no longer due any deference. Anyway, it appears that Mr. Alfaro Manzano appealed, a bit risky given the possibility that the BIA would not only affirm the IJ on asylum denial, but reverse on the withholding of removal grant. But the BIA simply affirmed everything that the IJ had done. That means that Mr. Alfaro Manzano is safe in the United States. He's got withholding of removal. But he took the asylum denial to the Ninth Circuit. Only through asylum, after all, can he get a green card and permanent safety. The Ninth Circuit agreed with him. The court believes that religion was one central reason for the harm he suffers and fears, and so he likely deserves asylum. Recently, the Ninth Circuit again, quote, defined a central reason as a reason for primary importance to the persecutors, one that is essential to their decision to act, end quote. I like that. Mixed motive cases happen all the time, and they're not always easy, explained the court. To be a satisfactory one central reason, the reason can't be incidental, tangential, superficial, or subordinate. But also there can be multiple reasons, and there can be multiple central reasons, said the Ninth Circuit. That's what often happens in the Ninth Circuit's, quote, extortion-plus, end quote, decisions. Yes, the gangs want money, but they also might target for extortion or harm because of a protected characteristic. Digging deeper, there are two ways to determine one central reason of the Ninth Circuit. Quote, a motive is a central reason if the persecutor would not have harmed the applicant if such motive did not exist, end quote, like a but-for cause. But two, quote, a motive is a central reason if that motive, standing alone, would have led the persecutor to harm the applicant, end quote. Here, the IJ and the BIA erred, believing that just because Mr. Alfaro Manzano would have likely been targeted for extortion anyway, because that's what happens in the town, he couldn't establish the required nexus for asylum. That would be but-for reasoning, in the reverse. But but-for is only one way to do the nexus inquiry. Dicta from prior precedent and Attorney General Sessions in his vacated matter of AB decisions be damned. Which, even if good law, would no longer be subject to Chevron Okay, I'll stop. The other way to do the one central reason analysis is to again ask whether, standing alone, the protected ground would have led to the persecution. It's complicated stuff, and so this metaphor assisted me. Quote, imagine a bucket filling with water. The water represents a potential persecutor's motivation to harm someone, and when the bucket overflows, he acts. First, imagine the bucket is filled to the brim with water. A drop of water is added, and the bucket overflows. That additional drop is technically a but-for cause of the overflow, but we would likely call the drop incidental, end quote. That wouldn't cut it, but to be clear, explained the Ninth Circuit, the protected ground need not be 51% of the water to win, even under the but-for analysis. That's interesting. But went on, explained the court, it could also be the case that there is enough water coming from two sources to make the bucket overflow. Just because they're coming at the same time doesn't kill nexus. And that's what the Ninth Circuit believes is happening here, in so many words. The gang members clearly didn't like that Mr. Alfaro Manzano was preaching. They threatened to kill him a few times and tried to run him off the road into a tree. And they called him a testicle, explained the Ninth Circuit. That they also demanded money isn't that important to the nexus analysis here. And oh, by the way, the Ninth Circuit is quite clear, contrary to what the immigration judge found, that Mr. Alfaro Manzano's credible testimony on motive was enough in this case. Plus, of course, the expert, right? Remember the expert? Quote, if this is not an extortion-plus claim, it is unclear what would be, end quote. Preach! Or don't, at least in El Salvador. Pun not intentionally intended, but now intended. The Ninth Circuit therefore sent it back, instructing the BIA or IJ to grant Mr. Alfaro Manzano asylum unless they determine that he doesn't warrant it as a matter of discretion. What a win for your clients, Jordan E. Cunnings of the Innovation Law Lab in Portland, Oregon, and Stephen W. Manning for petitioner. And that is Manzano v. Garland. Say goodbye to missed calls and wasted time on unqualified consultations. With Staffy Live, you get a dedicated team of truly bilingual and highly empathetic specialists answering the phones for your immigration law firm 24/7. Staffy Live specialists go beyond just answering calls. They qualify callers by asking the right questions, ensuring that only qualified consultations make it into your calendar. Plus, they don't stop there. Staffy Live can also handle follow-ups, so you can focus on what you do best, practicing law. Staffy Live is a service for immigration law firms only. And here's the best part. You can try Staffy Live absolutely free for 15 days, no strings attached. Just visit www.staffy.cc, that's stafi.cc, and click Get Started. Of course, use the code FREE to claim your free trial, or click on the links in the show notes. Finishing the episode with two crimmigration decisions. And again from the 9th. First, Leon Perez v. Garland, published by the 9th Circuit on June 28th, 2024. I'm not gonna lie, it was a long and stressful week, and I did not need this on a Friday afternoon. But I do not control those circuits. This case is about the ever-complicated sexual abuse of a minor, aggravated felony definition. Mr. Leon Perez is a 26-year-old man from Mexico. He's been a lawful permanent resident since 2018, going through the U visa process, or possibly as a U visa derivative. 4 years later, though, and so I guess in his early 20s, he was convicted of attempted lewdness with a child under the age of 14, in violation of Nevada Revised Statute Sections 193.330 and 201.232.2. Also, and quote, not pertinent to this appeal, attempted incest, end quote. He received a really large prison sentence, but all of it was suspended and he was placed on probation. Wild what happens in the criminal justice system. So, attempted lewdness with a child under the age of 14 in Nevada. If it's an aggravated felony sexual abuse of a minor as defined at INA Section 101A43A, he's removable and he loses his green card. And actually, DHS caught itself and later amended the removability charge to be a Section 101A43U attempt to commit any other aggravated felony, which is then itself an ag-fel, the underlying attempted aggravated felony being a Section 101A43A offense. Because it seems that Mr. Leon Perez conceded or didn't argue that Nevada attempt is the same as the attempt definition used at INA Section 101A43U, it still all came down to whether the underlying offense, if completed, would match the definition of a Section 101A43A sexual abuse of a minor, aggravated felony. Long episode, and man is this stuff complicated, so suffice it to say, the IJ and the BIA so found. The INA is, dare I say, ambiguous on what the definition of sexual abuse of a minor is. The BIA and the circuits, including the 9th Circuit, have been piecing it together for years. The Supreme Court said in Esquivel-Quintana that for statutory rape-type offenses at least, the statute itself, the criminal state statute, must require that the victim be under the age of 16. For other crimes, though, explained the panel, the 9th Circuit has previously held that the generic definition of sexual abuse of a minor requires that the state statute require in turn 3 elements, quote, 1, sexual conduct, 2, with a minor, 3, that constitutes abuse, end quote. There is language in Esquivel-Quintana, though, that would support an argument that for non-statutory rape offenses, the generic definition of sexual abuse of a minor should be tethered to the federal offense at 18 U.S.C. Section 2243, which in turn requires as an element, quote, at a minimum intentional touching of genitalia underneath the minor's clothing, end quote. That's more than the 9th Circuit standard that I just quoted. And then the Nevada statute at issue here appears not to require that, at least argued Mr. Leon Perez. The 9th Circuit, however, wasn't having it. It held that its prior definition governs even after Esquivel-Quintana for non-statutory rape offenses, that is, the definition from United States v. Medina-Villa. Simply put, the 9th Circuit doesn't believe that the Supreme Court in Esquivel-Quintana said much about anything when it came to non-statutory rape-type offenses, or that Section 2243A was the exclusive way to define the generic definition in other contexts. The INA aggravated felony definition doesn't reference that statute, for example. The court believes that at least the 2nd, 3rd, and 7th Circuits have reached similar conclusions. Applying then the Nevada offense to the Medina-Villa elements, the court held that it meets it. Trigger warning 2. The Nevada statute requires, quote, a mens rea requirement that the perpetrator's intent be one of arousing, appealing to, or gratifying the lust or passions or sexual desires of that person or of that child, end quote. That's sexual conduct. It also, of course, requires that the child be a minor, and to the 9th Circuit is per se abusive, because the victim must be under 14. All of the elements required of Medina-Villa. The 9th Circuit doesn't believe that more analysis is needed on the abuse stuff because of the victim's age. notwithstanding Mr. Leon Perez's arguments. The Ninth Circuit is saying here that sexual stuff committed against someone under 14 is per se abusive. End of the analysis. That means that Mr. Leon Perez lost his green card and will likely be removed. Finally, and simply because I have nowhere else to put it in this episode, the Third Circuit said this week that 18 Pennsylvania statute annotated section 2702A is divisible, and that its subsection A6, aggravated assault, is a crime of violence. In the sentence enhancement context, of course. That's United States v. Hurt. But mostly, that was Leon Perez v. Garland. We conclude with Cordero Garcia v. Garland, published by the Ninth Circuit on June 27, 2024. This decision was inevitable, and recently argued in San Diego too, which is a bit rare for the Ninth Circuit. This case is about aggravated felonies, those defined at INA Section 11843S, an offense, quote, relating to obstruction of justice, end quote, for which the term of imprisonment is at least 1 year. The Supreme Court reviewed this very aggravated felony and this very case on episode 165 in Pugin v. Garland. Pugin was only one of the non-citizens in that decision. Mr. Cordero Garcia was the second, and the Supreme Court vacated the Ninth Circuit's prior decision in this very case, previously favorable to Mr. Cordero Garcia and non-citizens all throughout the Ninth Circuit, which had relied on the Ninth Circuit's precedential decision in Valenzuela-Gallardo v. Lynch. It's a very complicated procedural history, but it's really not that important anymore. Here we are. California Penal Code Section 136.1b1 is now an aggravated felony, and Mr. Cordero Garcia is now removable. Mr. Cordero Garcia is a lawful permanent resident, but in April 2009 he was convicted of violating that California statute, which essentially criminalizes attempting to prevent or dissuade a victim or witness from reporting a crime, even if the crime hasn't been investigated by anyone yet. He got a sentence to 2 years for it, so if the elements match the definition of relating to obstruction of justice, it's an aggravated felony, and Mr. Cordero Garcia loses his green card. In a series of complicated decisions, the Ninth Circuit and some other courts said that crimes like this don't match that definition because, again, essentially, the generic definition of obstruction of justice requires an ongoing investigation. But conviction here under this California statute can occur based on acts that are pre-investigation. Indeed, before law enforcement even knows that a crime has occurred. Again, to get there, it was like multiple Ninth Circuit decisions, multiple precedential BIA decisions, including a precedential BIA decision in this very case, getting vacated by the Ninth Circuit. It was kind of madness. But now it was all vacated by the Supreme Court. Last term, the Supreme Court held that Section 11843S offenses, the generic definition, includes those that in turn criminalize, quote, threatening a witness to prevent the witness from reporting a crime to the police, and does not require that an investigation or proceeding be pending, end quote. So Mr. Cordero Garcia is in trouble on remand. He no longer therefore argued that the statute isn't an aggravated felony because it criminalizes mere attempts at dissuading reporting a crime, because the Supreme Court kind of just said that that stuff is covered by the generic definition. Instead, he argued that Section 11843S is a specific intent crime, but that Cal Penal Code Section 136.1b1 is not. A mens rea argument. And yes, the aggravated felony definition does require a specific intent. In cases like this, at least, quote, to prevent the witness from reporting a crime to the police, end quote. But the parties also agree that Section 136.1b1 is a specific intent crime as well. It requires that the defendant had the, quote, intent to prevent a crime from being reported by a victim or witness, or the intent to induce a witness or victim to withhold evidence of a crime from law enforcement officials, end quote. Those seem like pretty similar mental states to the Ninth Circuit. Mr. Cordero Garcia argued that, well, a different section of the statute, subsection A, aggravates the offense when done maliciously, which is defined under this statute as, quote, an intent to vex, annoy, harm, or injure in any way another person, or to thwart or interfere in any manner with the orderly administration of justice, end quote. That's a more culpable mens rea and seems closer to the mens rea that the Supreme Court was describing in Pugin, argued Mr. Cordero Garcia. And well, as it applies only to subsection A and not his subsection B offense, his conviction wouldn't have a sufficiently culpable mens rea. It's a complicated case, right? Maybe so or maybe not, explained the Ninth Circuit. It wasn't that interested. What it was interested was California appellate case law directly on point in the Section B1 context, holding that a specific intent, quote, to induce a witness or victim to withhold evidence of a crime from law enforcement officials, end quote, is required to convict. And that satisfies the Supreme Court's mens rea standard from Pugin, irrespective of what subsection A says. Mr. Cordero Garcia suggested that actually a defendant might merely intend to protect a witness or victim from prejudicial publicity or retaliation by the perpetrator, not to interfere with the process of justice, and that wouldn't match the aggravated felony definition. That wouldn't have the required intent. But Mr. Cordero Garcia didn't have a case to support his hypothetical. Restated, with a statute that is a presumptive match to the removable offense, Mr. Cordero Garcia had the burden to get out from under it by finding a case. That's how the realistic probability test is supposed to work. When the statute's a match to the removable offense, the non-citizen can still get relief if he can find a case applying the statute overbroad. Mr. Cordero Garcia couldn't do so here, and because the Ninth Circuit deemed the statutory text a match to the Supreme Court's new generic definition of a Section 101A43S offense, that sealed his fate. Not only that, explained the court, based on the Supreme Court's new definition of the offense and the importance of the word, quote, relating to, end quote, in this specific aggravated felony, an individual who has the specific intent to impede reporting of a crime still satisfies that definition, even if the ultimate goal is something other than thwarting investigation of a crime. So pretty bad ruling for Section 101A43S offenses and California crimmigration attorneys generally, who used to plead down their clients to Cal Penal Code Section 136.1b1 offenses. And pretty bad for non-citizens in regard to other removability provisions that use the phrase relating to. But also the die was kind of cast with Pugin last term. Final thoughts and just kind of spitballing. In its final footnote, the Ninth Circuit says, quote, "We reject Mr. Cordero Garcia's retroactivity argument. Our holding is based on Pugin, which in turn relied on the plain language of Section 101A43S and thus raises no retroactivity concerns as applied to our direct review of the BIA decision," end quote. So essentially, the Supreme Court's new definition of a Section 101A43S offense can be applied to Mr. Cordero Garcia because really, the Supreme Court was saying what the statute's text always meant. But if that's the case here, is it not also the case that when the Supreme Court issues a holding reinterpreting the text of an immigration statute in a manner favorable to non-citizens ordered removed on that basis should have their cases reopened? Because the Supreme Court, again, is interpreting what the statute's text always meant, right? Different legal frameworks for sure, but the logic sounds compelling to me. And that is Cordero Garcia v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.